Most seniors think adding a name to a house deed is just a simple family decision. It feels loving, practical, and safe, especially when the goal is to make things easier later. But the truth is that one wrong name on a deed can create inheritance problems, title issues, and financial complications that can follow a family for years. That is why this matters so much. A house is not just a house. For many seniors, it is the biggest asset they own, the place they paid for over decades, and the one thing they want to pass down without trouble. When someone says, just add this person to the deed, it can sound harmless. In reality, it can be one of the most expensive mistakes a family ever makes. Today I want to walk you through 3 kinds of people seniors should be very careful about adding to a house deed. Now, these are not unusual edge cases. These are the exact kinds of situations that quietly cost families thousands of dollars and sometimes much more. Most people do it with good intentions. That is what makes it dangerous. Before we get into it, let me be clear. This is general educational information, not personal legal advice. Property rules, tax rules, and estate rules vary by state. Always check your own situation with a qualified attorney or local professional before making changes to your deed. This is the most common mistake seniors make. A parent will often say, I want my son or daughter to get the house anyway, so why not add their name now? Or my child helps me with everything, so it makes sense to put them on the deed. Or, I do not want probate to be a problem later. Those are understandable reasons. They sound practical. They sound loving. Adding an adult child to your house deed is not just a paperwork change. It is a transfer of ownership. And once that child is on the deed, the house may no longer be fully under your control. That is where the risk begins. If your child has debt, gets sued, files for bankruptcy, goes through a divorce, or runs into legal trouble, your house can become tied to those problems. Most parents do not think about that. They think, this is my child. I trust them. But trust is not the only issue. The law now sees them as an owner, and their problems can affect your property. Let us say your child is on the deed and later gets sued after a car accident or a business dispute. Suddenly, creditors may see the house as a possible target. The same is true if they go through divorce. The home may become part of a legal fight you never intended to start. What was supposed to be a simple family gesture can turn into a legal headache. There are also tax concerns. In some cases, adding a child to a deed can create a basis problem later when the house is sold. Families often do this to avoid taxes, but the move can end up creating a bigger tax bill in the future. People hear one side of the story and rarely hear the downside. That is how mistakes happen. And there is another issue people do not think about enough: control. If your child is a joint owner, you may no longer be the only person who can make decisions about the house. That matters if you later want to sell, refinance, or change how the property is handled. If the relationship changes, or if your child is difficult to reach, the whole situation becomes messy. A lot of seniors do this because they want to avoid probate. That goal is understandable. Nobody wants their family stuck in a long court process. But adding a child to the deed is not the only way to deal with inheritance. In many cases, there are safer tools, such as a will, trust, or transfer method, that fit the situation much better. The big lesson here is simple. Love is not the same as ownership. You can trust your child completely and still not want them on the deed. In fact, the safer choice is often to keep the house in your own name and use a proper estate plan instead. Practical action. Review your deed and ask whether the child's name is there for convenience, inheritance, or actual ownership. The second one catches people off guard because it feels romantic and fair. Senior meets someone new later in life. Maybe it is a second marriage after divorce or widowhood. Maybe it is a long-term partner. The relationship feels serious, and the natural thought is, we should put both names on the house so everything is fair. Or, if anything happens to me, I want them to be protected. That sounds loving, but it can also be dangerous. When you add a spouse or partner to the deed, you are giving them legal ownership. That means if the relationship breaks down later, the house can become part of a separation, divorce, or property dispute. Even when a relationship starts out strong, life can change. Illness, conflict, money, stress, family disagreement, and outside pressure can all create new problems that were not there before. There is also the issue of financial baggage. A new spouse or partner may have debts, lawsuits, credit problems, or past financial obligations that you do not fully know about. Once that person is on the deed, their financial world may become connected to your home. That is a risk many people do not see until it is too late. This matters even more in later life relationships because both people often already have children from prior marriages, separate savings, and very different inheritance plans. A simple deed change can accidentally override the plan you thought you had. Maybe you wanted the house to go to your children someday. Maybe your partner expected to stay in the house for life. Maybe both of you assumed the arrangement was temporary. Once ownership is shared, nothing is as simple as it looked on the day you signed. People often confuse trust with protection. They think we love each other, so this must be fine. But love does not prevent legal complications. In some cases, it creates them. That does not mean you cannot protect a spouse or partner. It means the deed may not be the right tool to do it. There may be better ways to make sure someone has security without putting the whole home at risk. That is why people should slow down and get advice before adding a name. The deed is not where emotion should make the final decision. If the relationship is still new, that caution matters even more. A lot of people rush this because they do not want to seem untrusting. But protecting your house is not a sign of disrespect. It's just smart planning. Practical action: compare the deed with your estate plan and see whether the house is actually titled the way you intended. The third group to be careful about is caregivers, helpers, and friends. This is often the quietest mistake because it starts with gratitude. A helper may run errands, drive to appointments, buy groceries, or check in regularly. Over time, the senior may begin to rely on them and think they deserve something for all they do. The issue is not kindness, but the issue is ownership. A person who helps you does not automatically need to become a co-owner of your money or your home. In fact, that can create a bigger problem. Once a caregiver or friend is on the deed or account, the line between help and control becomes much harder to define. Why do seniors make this mistake? Often because they are lonely, tired, or relieved to have support. Sometimes they do not want to seem ungrateful. Sometimes they believe the relationship will always stay the same. But relationships can change. A helper can move away. A friend can fall into financial trouble. A caregiver can become over-involved. If the title is already shared, the senior may be stuck with consequences they never intended. One overlooked issue is family tension. Adult. Children later see a non-family helper on the deed. They may question whether the senior understood the arrangement or felt pressured. Even if the senior was fully aware, the family may still argue. That can lead to painful accusations and a difficult cleanup process. A practical consequence is that a senior may lose flexibility. If the helper is on the title, the senior may need their cooperation later to refinance, sell, or make changes. That can be especially difficult if the relationship changes or communication breaks down. Here is a simple example. A widow adds a close neighbor to her checking account because the neighbor helps with groceries. A year later, the neighbor moves and stops answering calls. The account still has both names. Now the widow has to sort through paperwork just to regain control. What seemed like a small favor became a legal hassle. The safer way to think about this is to keep gratitude separate from ownership. You can pay someone, thank someone, or arrange formal help without putting them in charge of your property. That is a much cleaner line. There is another issue almost nobody talks about. When someone has ownership, they may also have a say in what happens next, even if that was never discussed. That can affect family plans in ways that only appear later, when the senior is older and fewer people are paying attention.
Practical.
Write down exactly what help you want, then check whether that help really requires shared ownership. Most people do not make this mistake because they are careless. They make it because they misunderstand what a deed really does. They think adding a name means, this person can help if needed. But legally it often means, this person now owns part of the home. That difference is huge. Ownership can mean the right to sell, the right to borrow against the property, the right to challenge decisions, and the right to expose the home to their own legal or financial problems. It also means the deed can affect inheritance in ways many families never expect. So when someone says just put their name on the house, they are often skipping over the most important part. Once the name is on there, you may not be able to treat the house as only yours anymore. That is why the deed is not something to handle casually. It looks like a simple form, but it can control one of the most important assets in your entire retirement. One detail many retirees do not realize is that the exact wording on the deed can matter. Different forms can create different ownership rights, and those rights can affect what happens later if one owner dies or wants to change the arrangement. That is one reason local rules matter so much. Practical action: pull out the current deed and read every name exactly as it appears, then compare that with what you thought the ownership was. It is worth pausing here because most of these mistakes come from good intentions. A parent wants to help a child. A widow wants to make sure a partner is protected. A senior wants to thank a caregiver. A family wants to avoid probate. A homeowner wants everything to be easy later. None of that is foolish. In fact, it is very human. But good intentions do not protect a home from lawsuits, debt, divorce, creditor claims, family conflict, or tax problems. That is why these mistakes happen so often. The person signing the deed believes they are solving a future problem, but they may actually be creating a much bigger one. The sad part is that most of the damage does not show up right away. Everything looks fine at first. The house is still standing, the relationship seems good, the child is still helpful, caregiver is still kind. That is exactly why people do not notice the danger until something changes. By then, it may be too late. For retirement, that matters because the home often represents stability, savings, and independence all at once. If the title is changed carelessly, a retiree may lose flexibility at the very time they need it most. The house is often part of the retirement safety net, so the wrong change can ripple into the rest of the financial plan. Practical action: before making any change, write down your real goal in one sentence and check whether the deed is the right tool for that goal. When deed mistakes go wrong, the impact is not just legal, it is emotional. Families can end up fighting over who owns what. Children may argue about whether their parent made a good decision. Spouses may disagree about whether a home should be shared. A caregiver situation may turn into a trust dispute. And in the worst cases, the family home can become the center of a long legal battle. That is why people say these decisions can cost thousands of dollars. It is not just about a filing fee. It is about the chain reaction that can follow one wrong signature. Sometimes the cost is a tax bill. Sometimes it is legal fees. Sometimes it is the expense of fixing the deed. Sometimes it is the cost of family conflict. And sometimes it is the loss of control over the house itself. For a senior living on a fixed income, that can be devastating. One practical tip many people overlook is this: even if the home is fully paid off, the title still matters. A paid-off house can still be tied up in the wrong ownership arrangement, which means the lack of a mortgage does not equal the lack of a problem. That is a big misunderstanding in retirement planning. What if the person you added later needs to file bankruptcy, gets divorced, or disagrees with your family after you are gone? That is when the title becomes more important than the balance in the bank account. Practical action: check whether your home is one of your main retirement assets and treat the title with the same care you would. Use for an investment account. Well, the best mindset is this: do not rush to add anyone to a deed unless you fully understand what that means. If the goal is to help someone, there may be another way. If the goal is to pass the house later, there may be a better tool. If the goal is to avoid probate, there may be a safer option. If the goal is to protect someone, there may be a legal structure that does it without changing ownership right away. The right move depends on the family, the state, the taxes, and the overall plan. That is why a deed should never be changed just because it feels easy. Easy is not always safe. A better way to think about retirement protection is to ask whether the choice keeps your independence while you are alive and keeps your family from unnecessary complications later. A good plan should protect the home without exposing it to avoidable risk. Practical action: discuss the decision with family before signing anything, and make sure everyone understands the goal, not just the paperwork. If you remember nothing else from this video, remember this: a deed is not a casual form. It is ownership, and ownership can change everything. The 3 people you should be extremely cautious about adding to your house deed are adult child, a new spouse or partner too early, and a caregiver, helper, or friend. Those are the 3 that can cause the most damage when the arrangement is not carefully planned. A lot of seniors think they are protecting their family by adding a name. In many cases, they are actually putting the home at risk. The result can be inheritance problems, title problems, and thousands of dollars in avoidable losses. That is why the safest move is almost always to slow down, ask questions, and get proper advice before you sign anything. Your house is too important to hand over casually. The three biggest takeaways are simple. First, adding someone to a deed can mean ownership, not just help. Second, the wrong person on a deed can create real retirement risks later. And third, there are often safer ways to plan than changing ownership too quickly. Before making any change, review your personal documents carefully and make sure you know exactly whose name is on them and why. Then speak with a qualified professional about the safest option for your own situation. If this helped, please like the video, subscribe for more retirement protection tips, and share it with someone who should review their own documents before making a change.